what time it is. Buckle up and enjoy the ride. And we are live. Greetings to our loyal WFYL listeners around the world. Welcome back to your Philadelphia live stream, only on the Freedom Station. I want to thank each and every one of you for tuning in once again, because you still have the right to hear and the right to be heard. Ladies and gentlemen, my name is Mike G. As always, with me are Russ, the producer, and Liberty Lee. And you're listening to Mike G in the morning with The Law Matters. And you can listen to our program every Friday at 7 a.m. Eastern, only on the Freedom Station, WFYL. So let's be heard. You know, ladies and gentlemen, we have been off the air for quite some time, but we're back in action, and we've got a couple of very special guests joining us today. We've got the one and only Dr. Val Finnell. I see you listed as Colonel there, so should it be Colonel, Doctor, Colonel, just the Doctor? What do you think, Dr. Val?
Anything but late for dinner. That's
anything but late for dinner works for us. And we've got the one and only attorney Richard S. Roberts Jr., the other half of the Justice Brothers. Rich, thanks for joining us.
Thanks for having me, Mike. Good to be here. Dr.
So we've got a lot to talk about today. Dr. Finnell, we understand that you've got this newer venture. I don't want to call it a new venture, but you've got this newer venture that you've taken on, and our audience would like to hear a little bit about it. So why don't you go ahead and fill us in?
Well, you might remember that I was the Pennsylvania director for Gun Owners of America for about 3 to 4 years.
Oh, hold on. Did you say you might remember?
You might remember,
unless you've been living under a rock or something, right?
right. So I left GOA, back in January, February timeframe. We started a new endeavor now. It's a super PAC, not an ordinary PAC, but a super PAC. And the super PAC will focus on electing pro Second Amendment candidates, both in Congress and also on the state level in Pennsylvania, and also holding our elected officials accountable, holding incumbents accountable for their votes and how they actually vote. So if folks remember, we had some big oopses in the Pennsylvania state legislature where red flag gun confiscation orders and universal background check registration schemes passed the House because of Republican support. So we're planning on holding some people accountable for those bad votes. And but that's it. We'll have a federal focus as well as a state focus.
Let's back this up a little bit, because you said it's not just a plain old PAC, it's a super PAC, right? So that's
right.
Better than a 6-pack, better than a 12-pack. Maybe it's one step below the super duper PAC, but it is in fact a super PAC. For our listeners who might not be familiar with these terms, could you just fill us in on what exactly that means?
Yeah. So when people think of political action committees, PAC stands for political action committees. There are really two varieties. There's kind of the regular variety PAC, or what they call a hard money PAC, where contributions are collected and people give that money to candidates. That's your plain old run-of-the-mill vanilla PAC. A super PAC is a PAC that is allowed to collect unlimited amounts of money and spend unlimited amounts of money. Regular PACs have limits on how much they can give the candidates in some cases, but super PACs can spend unlimited amounts of money in support or against candidates, but what they cannot do is coordinate with candidates. That's the big no-no with a super PAC, right? So there's a state super PAC, which I managed on the GOA side for about 2 years, and there's also a federal super PAC. So Keystone Victory Fund, which is the name of our super PAC, will be operating on both of those levels. But the key thing is, as they cannot coordinate with candidates, which is great. We don't want to coordinate with candidates, and we certainly don't want to give money to candidates. And the problem with giving money to candidates is once you give it to them, they can spend it however they want, and they can even turn around and give that money to anti-gun candidates. So to protect the Republican majority, or because I had a friend down the street tell them so. So it's always better for us to control those expenditures, and that's what a super PAC allows us to do. With that caveat, that huge caveat, that we cannot coordinate with candidates. We cannot pick up the phone and talk to a candidate and coordinate with them and how to spend the money.
And you couldn't stand dealing with those politicians anyhow, right?
Yeah, we want to keep arm's length, if we can, and be as objective as possible, and that's kind of what we want to do. And again, I go back to the holding the incumbents accountable for their votes. I mean, there's as I've said on the show often before, many times before, there's legislative season and election season are inextricably linked together. So what happens in legislative season, the votes in the legislature move over to legislative season. It's system of rewards and punishment. So if they voted right and they were champions, they get support. If they didn't vote right, they get punished. And so that's the way it works. And where we have failed in the past is we failed to hold so-called pro-gun candidates, whether they're Republicans or Democrats, hold them accountable for those votes, right? So give them a pass. We can't do that. We can't count on people who say they're for the Second Amendment, or at least for the Second Amendment on paper. We certainly can't count on people who are to the left of them and are not for the Second Amendment. So that's what we try to do is to keep people in line. And so you have to connect those two things: how votes happen in the legislative season and what happens in election season, who gets endorsements and who gets opposed.
So I heard that you were quoted in an article fairly recently, making waves out of the gate. How long have you been up and running with the Super PAC? I guess that's my first question.
We incorporated at the end of April, and we got things up and running with the registrations. So we've been live with the website and social media for a few days now, actually. But
just a few days.
Yes,
so
we've been working in the back for 2 months. And
so this is brand spanking new as far as the public is concerned.
That's exactly right.
So how did you end up getting quoted in this article? What's going on with that?
Well, the key is, Jim Kenney wants to sue, gun stores out of existence. That's one thing. People are buying. I guess there was the mass shooting in Philadelphia on Monday, and because of that, Jim Kenney wants to bring has threatened lawsuits against the FFLs in Philadelphia. Now, I don't know if people realize this or not, but there are actually less FFLs and less gun stores in urban areas than there are in rural areas per capita. So it's already more difficult for people to buy firearms in cities legally. And that's true across the board. I think it's by a factor of 2 from rural areas to urban areas. So here's Jim Kenney saying, hey, wait a minute, we're going to make it even harder for law-abiding Philadelphians to go down the street to buy a gun. You might have to, go to take a 30-40 minute trip to a suburb to purchase a firearm. We're going to make it harder for you to buy a gun to defend yourself, because those criminals are just going to obey the laws, and, they're not going to be able to obtain a firearm somewhere else. Right. So that's the big issue right there with that is the criminals are not going to obey the law, and yet they want to sue gun stores out of existence in the city of Philadelphia.
Yeah, Rich has got a good story about that. We were talking to a prosecutor who, after a PICS denial, this guy had been convicted of a crime probably before I was born, and he was claiming that he was keeping guns off the streets and fighting gun crime by prosecuting this gentleman for getting one of the questions wrong on the form. And this happens every single day in Pennsylvania. Rich and I get, I don't know, 3 or 4 of these calls every day where somebody's getting prosecuted. But and when the prosecutor made that claim, Rich had a pretty good comeback for the guy. I don't know if you recall this, Rich. Do you remember what you told the prosecutor during that conversation?
Yeah, I think it was something it was a snapback. I said, listen, if someone wants to illegally buy a handgun, they go to Clayton, but they don't go to Clayton's gun store or Bob's gun store, or wherever he went to. And they're certainly going to Bob, but nobody's going to Bob's gun store. Give me a break. Not stopping anybody.
You might go into an alley somewhere and buy it out of the back of a trunk.
Right, and let's not forget, Jim Kenney is the mayor who tried to ban guns in city parks and making every law-abiding citizen a target in city parks. So this is a pattern for him. It's like, where did they get this guy?
but don't you think it's pretty ironic when they try to implement these bans that violate the law, right? Because they violate the preemption law. and they say we're gonna fight, we're gonna stop people from breaking the law by breaking the law ourselves.
Right.
It's just you
Too
can't make
corporate.
any sense of it. You can't
Right.
make
The
any
two wrongs
sense of
make a
it.
right fallacy. Right.
So, what exactly did you end up saying? What were your comments on this that got so much traction?
Well, it was two things, and it was his hostility, Jim Kenney's repeated hostility against the Second Amendment. Going after law-abiding illegal gun stores, as if gun stores are the problem, especially in urban areas where there's less concentration of gun stores than in rural areas. And the second thing is, this the same mayor, the same person who tried to ban guns in city parks not too long ago. And even before that, the city tried to enact, a ban on homemade firearms. There was a lawsuit about that. It's just it's a repeating pattern over and over again. And what happened today? What was or yesterday? There was an announcement that
Another lawsuit.
another lawsuit, right? The Giffords and the city of Philadelphia and Jim Kenney suing JSD Supply, and P80 for homemade firearms again. Saying there's all these crime guns that have turned up on the scenes, and it's like they try to confuse people with this. They say crime guns, so anytime there's a crime and they just recover a gun, I mean, as long as it's recovered and associated with a crime, it's a crime gun. Well, how many of those are actually used in murders? We never hear that figure. I've never heard that figure. And we can't, it's like, I'd love for a reporter just to ask that question. What percentage of those guns of homemade firearms were actually made or were actually used in murders? We never hear this statistic.
Well, when we hear about crimes, that could be any number of different things, right?
Yeah, it can be anything associated with a crime. And if they discover a homemade firearm.
Well, the gun could be the crime itself, right? If you've got some kind of a possessory offense, whether it's 6108, right? The one that deals specifically with cities of the first class that they get a lot of people on, or something as simple as what Rich and I deal with quite often, where somebody doesn't go get their license to carry firearms. And I suppose in Philadelphia, you're going to see that one in addition to 6108 typically, but somebody doesn't have their license to carry firearms, and they're not ineligible for a license to carry firearms. They just don't have it. And had they taken a few minutes and gone down and filled out the application, then they would have been perfectly lawful. That's not necessarily the dangerous kind of person that you should be concerned about, right?
Right. And the blatant lies in the press conference that it's illegal in Pennsylvania to buy these guns. Not true at all. And they said that multiple times.
Oh, did they?
Yeah, they did. You can hear Jim Kenney say that it violates Pennsylvania law to buy a P80 kit. This is not the case at all. I mean, you can. We've had the right to build our own firearms since the beginning of the country and before, and as anyone can buy the components and assemble the firearm. Now, if you're a prohibited person, once you assemble it, you can't have it anyway. But there's no law that prohibits you from assembling your own firearm, and they're confusing people.
Possibly be ignorant, though, right? That's a blatant lie.
It's a blatant lie.
It's a lie with a purpose. We saw this with the city of Harrisburg case, because I recall coming out of our hearing and the cameras being around and the mayor getting on camera. And of course, the cameras weren't allowed in the courtroom, so nobody could actually see what was being argued. But the mayor gets in front of the camera and says they went in that courtroom and they argued there should be no gun laws whatsoever. That's not even close. And I don't perceive you as a stupid guy, Mayor. So as a result, you are intentionally lying to the public to try to make us seem unreasonable and ridiculous. Now, Rich, I know you and I had briefly touched on this particular case, and I'm sure that you didn't get a chance to look into it. But what are your initial impressions about a lawsuit like this, where you've got the government and you got this organization coming and they're suing these manufacturers? They're not manufacturing firearms. They're also not breaking the law. They're coming out and filing this kind of a civil suit for negligence and public nuisance, I believe, are the counts that are brought against them. And keep in mind, ladies and gentlemen, that this is all very fresh information. We don't have all the information. But Rich, what was your general sense when you heard about that happening?
My general sense was frustration, because if you want to change the law and make it illegal to build these firearms, putting aside the constitutional issues of the thing, go change the law. I mean, you're trying to sue a manufacturer or any business out of existence because you don't like the business they're in is insane for a government to do. I find that completely unethical and a serious problem. Like I said, if you don't want these businesses to exist, legislate it out. Now, again, I would believe, and I would argue that's unconstitutional to do so. But putting that aside for a moment, that's the way you do these things. And when he's talking about Mayor Kinney there, it's the problem. You can't get through the front door. You're trying to come through the back door. I have a serious problem with that. I mean, if you can't get enough legislatures to agree with you to eliminate these guns and you think it's a problem, the way you solve that, or the way you attempt to solve that, is convince legislators to your position.
Right.
Same thing Dr. Val does with his super PAC. He's like, I want pro-Second Amendment candidates, and I want these people to be elected. And if he wants to change people's minds, you either vote new people in or convince the people who are on the fence to your side of the story. That's what the legislative process is. And when individuals go at legitimate businesses who are selling legal products that are not doing anything unlawful for simply doing a lawful practice, then I have a problem. Because it's not like these individuals are doing anything that's illegal. Anything. You may not like what they're doing. That's fine. But it doesn't mean you get to sue them out of existence. I had
two words. I had two words for this, in my reply to Jim Kenney's tweet. I called it publicly legal terrorism. I mean, it's legal terrorism against a lawful business. And you know what? Maybe, just maybe, it's a violation of the civil rights of those people who run those businesses. So maybe there should be a countersuit.
It is unfortunate because those things are not cheap to litigate, right? They're not inexpensive to litigate. And what ends up happening in a lot of these high stakes litigation is they end up paying money. I don't think that's going to solve the problem here, right? Because that's not what they're looking for. They're not going after their money in this situation. They want them gone.
Right.
So, and Rich, when you're talking about going through the back door because you can't get through the front door, isn't that really circumventing the will of the people, though? Because like you said, in order to carry out the will of the people, you got to convince them of your ideas. And if they're not voting in favor of what you're talking about, and you say, well, I know better than you do, so I'm going to break the law and I'm going to go around the back door in order to do this. You're not really following the will of the people, are you?
No, you're not. I mean, it may be the will of the people that elected him, but he's not the only one around. Philadelphia, City. I mean, so, people elected me to change. Well, unfortunately for your position, there's a lot more than just you around. And, again, the state law makes it pretty clear it's preemption. So you have to go to the state legislature to make any sort of change in the law. And you're like, well, I can't convince them. And I go, I'm sorry. I mean, there's nothing you could do. I mean, that's the way the system has worked for its entire existence here in Pennsylvania. So, again, it's sorry, but maybe you should think of another way to deal with it. I don't know, but you got to find a legal way, because I agree with what both of you said. You can't have two wrongs make a right. So you want to stop illegal by doing something illegal? That doesn't seem right to me. You're the government. You're supposed to do things, and your power is restricted, and people have rights. And the civil rights aspect is interesting. I don't know enough about that to comment on it, but that's an interesting way to look at it.
I think it's a lawsuit designed to deprive somebody of their right to own a lawful business. I mean, and in that sense, it's legal terrorism. I see this comment from Dag Nabbit. It's frustrating that it seems the government has unlimited funds for all these lawsuits. Well, here's what people need to understand. Organizations like Giffords has teamed up to conduct a financial war of attrition against your firearms rights, against your gun rights. So they pony up the attorneys, they queue up the attorneys for the city pro bono, so the city doesn't have to pay for them. Okay, and every town did the same thing for the Pittsburgh three illegal ordinances. So there's all this Bloomberg money coming into the state through these organizations that fund these lawsuits, and the city doesn't have to pay for them. Whereas you and I, as law-abiding citizens, as gun owners belonging to whatever gun rights organization you belong to, we have to pony up the money out of our pockets, send it into the organizations like Gun Owners of America, the NRA, Firearms Policy Coalition, whatever it may be. And it's those funds that honest people are donating to those organizations, that's what we're left to fight with. So we
That's
got
a good point. It's really not a fair fight, though, right?
It's not a fair fight. It's stacked against you because of Bloom bucks and the unlimited resources of government, in some respect, compared to limited resources for 501c4 membership organizations.
Yeah. Oh.
Now you sound like the mob did. Why can't you beat the government? Because they print money. They always have more money than me.
That's right.
They said they print money. I only got so much.
That's right. We only have so much.
You only have so much. Mob's like, you can't beat them. Why? Because they just print more money. They got more money than me. There's nothing I can do.
Mm-hmm.
So, Dr. Val, I know we've only got you for a short period today. We want to have you back on for an extended episode and really dive into what you've been up to. But if people want to hear more about what you're doing with your new venture, how can they get a hold of that website? What's the name of that website?
It's real easy. It's keystonevictory.com. Keystonevictory.com. Just go there. You can sign up for our email list. There's a place to make a donation if you'd like to make a contribution to the PAC, to the Super PAC. And you'll also find our social media links there. So just go to keystonevictory.com.
I just posted it in the chat, and it's a different sort of vibe than what you were previously doing, in that this is just solely you're solely looking for donations to continue up with the cause. It's not like you become a member and you get a t-shirt or anything like that, right?
That may be coming down the pike, as we may have incentives, and giveaways and things like that, but we're in such in the early stages. And what people have to understand is it's two sides of the same coin. What we do in the legislature to lobby to pass pro-gun bills will mean nothing if we can't elect pro-gun legislators, right? So you have to have both aspects of it. And that is what I've seen is the deficiency, in Pennsylvania and in other places is we need to really have a super PAC focused on this, where we can truly get, pro-guns, pro-Second Amendment candidates elected to office. And nothing's going to change in Harrisburg, unless we do that. So we could lobby until we're blue in the face. So, the Democrats have control of the House. So good luck trying to get anything passed.
And what was the last action on those bills that you referenced? I believe when I checked, it said that they referred to the judiciary on June 2nd or something. That's correct.
That. They went to the Senate Judiciary Committee, and that is chaired by Senator Lisa Baker, who is Pike and Wayne counties mostly. And there's been a lot of pressure on her to kill them in committee, just not bring them up for a vote. So, and multiple organizations have already been reaching out and contacting her. So, I would never say never, but it's very unlikely that those bills will see the light of day in the Senate.
Okay. All right. Well, we needed to keep it up to make sure it stays that way.
Yes, exactly. You have to keep up the pressure. And that's where you see the two things are linked together. If they don't do the right thing in Harrisburg, then that's where the PACs come in.
All right. Well, Dr. Val, thank you so much for joining us today. It's been far too long. Glad to hear that everything is going great for you. And we look forward to having you back on the program again soon.
Yes, thanks. Good to be on.
All right. Thank you, everybody. For those of us just tuning in, you're listening to Mike G in the Morning with The Law Matters, only on the Freedom Station, WFYL. So, Attorney Richard S. Roberts Jr., my justice brother, thank you for joining us. You have been really busy lately in light of decisions that have come down in terms of our Second Amendment and as applied challenges, and what the Second Amendment means and how it impacts some of these laws that have been on the books forever, right? And how they impact who's eligible to own and possess firearms. Isn't that true?
Yeah, it's been quite busy. We talked about the Bruen decision before, but recently the Third Circuit came down with a range decision about how to deal with as applied challenges following the Bruen framework announced by the Supreme Court.
For our listeners who might not be familiar with what an as applied challenge is, why don't you tell them a little bit about what it is all about?
Sure. So everybody's heard that people challenge statutes as being unconstitutional all the time, right? So there's two ways it's unconstitutional. One is on its face. That means no matter how the statute's applied, it's unconstitutional. For example, if somebody passed a statute, if Congress passed a statute said it would be illegal for anybody to criticize President Joe Biden, that's a clear violation of the First Amendment. It's unconstitutional on its face. Right now, what you have is an as-applied challenge, which, looking at the statute on its face, it can be constitutional, but it may not be constitutional as applied to a specific person or a specific circumstance. So the United States Code 922G is the general federal code which prohibits individuals from purchasing or possessing firearms if they have any prior felony conviction where the maximum possible punishment is greater than a year, misdemeanor conviction where the maximum possible punishment is greater than 2 years. So prior to this Third Circuit decision, and every other circuit court had a two-step process. They looked at, for lack of a better term, seriousness of the crime, and then if the crime wasn't sufficiently serious, they used typically intermediate scrutiny to determine whether or not the prohibition as applied to your particular client's valid. Brune did away with that. Now what we look at is the historical tradition, or the government has the burden to prove a historical analog during the founding period to demonstrate that the regulation of firearms today is consistent with the way the Second Amendment was understood when it was ratified.
So with the range case, and we have a case that is currently in that same court of appeals, and we had it pending, and it was actually put on hold, so to speak, while they were awaiting the range decision. And with the range case, they had a guy who was convicted of welfare fraud, right? He didn't.
Yeah.
He provided.
He provided false information. He got a few $1,000s, like 24 years ago.
I think he didn't report that he was making like $300 a month mowing lawns or something. It was something.
Yeah, something
ridiculous.
like that. Yeah, but he was basically he was overpaid by Medicare, like through whatever welfare fraud or whatever, about $3,000 or something. He paid the money back.
That conviction turned out to be a misdemeanor of the first degree, which under 18 USC 922G, as you said, would be prohibiting, because the max possible sentence on a misdemeanor of the first degree is 5 years. And you're prohibited under 922G if your max possible sentence is greater than 2 years. And I went to law school because I'm bad at math, but I do know that 5 is more than 2. And so as a result, he's put into that category. And the whole argument became whether that prohibition as applied to him was constitutional. And they were previously trying to work that out in terms of the old standard. Then when Brune came down, they analyzed it under the Brune standard, right?
That's correct. And the Third Circuit came down in that as applied to Mr. Range, it was unconstitutional to prohibit it from firearms because the government failed to show a historical tradition preventing individuals convicted of welfare fraud or historical analogs, something similar as being disarming, right? Because the way you have to look at the test is, for example, for a DUI case, for example, we have a couple of people that are considering doing as applied challenge, right? There's no cars and there was no driving under the influence. And I'm not aware of any driving a horse-drawn carriage under the influence crime, right? So they go, well, how? Well, Justice Thomas's opinion said, well, how do I announce this? There's no cars, there's no DUI. You're necessarily not going to find a DUI statute in 1789 or 1790 when the Second Amendment was ratified. How do I do it? Well, historical analog. So when I talk to these potential clients, I say something we would have to look at is habitual drunkards in town. You always read stories about them through history. What did they do with those individuals once they're classified as a guy who was always drunk, always sober, living on the street? Is there historical precedent during the founding that you disarm those individuals? Because if you could say that, the government could try to use that as a historical analog to say, hey, they disarm them, these habitual drunkards here, you should do it now. Now, the counter would be just because you're a DUI doesn't mean you're a habitual drunkard, but that's the kind of situation we're looking for. And that's the way we're going to address Second Amendment challenges going forward, at least here in the Third Circuit and everywhere else. And that's going to be a subject of pretty extensive litigation going forward as to when can you be stripped of your Second Amendment rights is really the next challenge. And interestingly enough, is the Supreme Court of the United States on the last day of its term took up a case which used the Brune test and is going to review that decision, come back in a year. And I'm sure, Mike, you and I will be talking about that decision.
Well, there are a couple of different decisions that are popping up all over the place in different circuits, and they all vary. It's very... there's a wide variety of fact patterns that we're looking at, right?
Yes.
So you have the one that deals with the restraining orders, and then you
Right.
have others that one dealt with, like we talked about off the air, somebody who was convicted of manslaughter and did, I think, 16 or 17 years of incarceration. And I think that what some of these judges are likely doing is they're seeing these challenges and they're bringing them to the extreme in hopes that the momentum will swing the other way. Because when you make a decision that seems so ridiculous that it shocks the conscience of the average person, you're going to get a reaction there, aren't you?
I think so. And the case that you mentioned about restraining orders is the one that the Supreme Court took up. There was a district court, and the Fifth Circuit affirmed that currently, if you're subject to an active protection from abuse order, which is what I know in Pennsylvania, they are called something else, a restraining order with a crime of domestic partner or something, you are prohibited while it's active from purchasing or possessing firearms. Gentleman after Brune challenged that and said, hey, there's no historical tradition for prohibiting an individual accused or subject to a restraining order, convicted of a crime of domestic violence from possessing firearms. The district court agreed, stating that when we look at the founding, women weren't citizens. They were treated as property, and there was no crimes of domestic violence, and therefore the government cannot sustain its burden. So it granted that he was allowed to purchase and possess firearms, even though he was subject to a valid restraining order. Got appealed to the Fifth Circuit. The Fifth Circuit agreed. And then the Supreme Court, on the last day of its term, said, we're going to take a look at this. And I think it fits with you, because I think what you're going to see is a pullback, because there's a lot of circuits that are taking pretty wide latitude. And I hate to say that about judges, but I agree. They take a very, very, very broad, expansive ruling of it. And my prediction, and now we'll have it on live radio here, that I think you're going to see it pulled back, because when you look at the Brune decision, you had the majority 6-3 said you got to use this historical tradition test. But when you read opinions, and this is fancy lawyer talk here, maybe too deep in the weeds, concurring opinions are opinions where the justice or judge, if it's a circuit court, agrees with the decision, but may agree with it to a certain point or for a different reason. And typically they don't really matter unless there's a sufficient number of judges that adopt that concurring opinion that you need to pay attention, because it's really a limiting principle. So in the Brune decision, you had Justice Kavanaugh, Chief Justice Roberts, and Justice Alito all say that nothing in that decision should cast aspersions on long-standing prohibitions for like felons in possessions and things like that. And if you combine that with the 3 liberal justices who dissented in opinion, that number is 6. So I think you may have a limitation or limiting or drawing back on that Brune decision based on the concurring justices. Justice Alito may dissent, but I think Kavanaugh, Justice Roberts, Kagan, Jackson, and Sotomayor, that's 5, which is more than 4. So I think it's not going to get overturned by any stretch of imagination, but I think we may have a limiting principle that comes out of it.
Yeah, because I think the average person hears the reasoning on that. Well, in the old days, they didn't care whether you beat your wife, and they're like, whoa, whoa, whoa.
Exactly. And currently the 8th Circuit has a decision where an individual had a couple felony conviction. He was charged federally with possession of a firearm by a prohibited person. He was convicted. Post-sentence, Brune came out before he was sentenced. He filed a motion asking for dismissal of that charge. And the trial court, the district court denied it. He appealed it. And the 8th Circuit quickly dispensed of that argument, saying that Brune provides a new avenue for a way to look at Second Amendment challenges. However, we do not need to do a felony by felony by felony by felony discussion of whether this particular felony is applicable and this felony is not. If you're convicted of a felony, they cited to the 2 concurring justices, did the addition I just did, and said, even Justice Alito said, this doesn't press any aspersion on longstanding felony position. You're a felony. This has been longstanding. This is the statute they're talking about. Go home. So he lost that.
Interesting, because different things were considered felonies over the course of history, right?
Correct.
That's changed in both directions, really. Some of the things that you'd be surprised at what is versus is not a felony. I want to go back to when you were talking about the misdemeanor domestic violence along with the restraining order, because the restraining order aspect, I think, has this separate layer to it, which has nothing to do with whether or not people think that you're okay enough if you beat your wife, right? It has nothing to do with that, but more to do with the process that's involved in order to strip you of those rights. Because you're not going through a criminal trial where it's beyond a reasonable doubt or anything of that nature. So, isn't there another consideration in those processes that you don't go through with something along the lines of a criminal conviction?
Well, yeah, most PFAs is preponderance of the evidence, right? They have to show by a preponderance of the evidence in Pennsylvania that the person whom you accuse is engaged in abusive behavior. Has to be a member of a particular, it has to be a family member. At a minimum, it's defined in Pennsylvania. It can be a close family member, so a sibling, a mother. I think it goes as far as cousin after that, the PFH statute, but really it's for domestic partners, boyfriends, girlfriends, living together, married spouses. And it is a preponderance of the evidence. And once you have that, the federal legislation doesn't make any distinction about whether it's, guilt beyond a reasonable doubt or preponderance of the evidence. So once that happens, during that period, you're stripped. I think the other thing that you run into is, well, I guess depending on the statute, the maximum a PFA can last in Pennsylvania is 3 years. I know in New Jersey, you were the one who educated me that on Mike, that it never goes away unless you do it.
And Rich Roberts' words, it's forever, ever.
Forever, ever. I was like, what? And we had a case about that, and the DA was like, really? It never? I'm like, it never goes away. It's away now because I didn't know that. I had to mention that, my partner, Mike G, told me, he's like, yeah, never, ever goes away. I'm like, why not?
Yeah.
But it's a New Jersey thing. But I mean, that's part of the issue.
So in Pennsylvania, I don't think a lot of people have experience with PFA, so they might not know what this really looks like when it comes down to it, how this stuff all shakes out. Would you mind just explaining the process just a little bit of what you see in these types of cases? And I'm going to let you run with this for a couple of minutes because I'm going to jump off here for about 30 seconds. But go ahead.
Right. So a PFA in Pennsylvania is a statutory process that's designed to protect family members is the general from abuse as defined under the statute. So typically what will happen is a boyfriend, a girlfriend will have something happen that they believe is abusive. It could be over the course of the relationship. It could be a single incident. So what will happen is they're allowed to go to what they call an ex parte hearing. So it's an emergency application. So that means the other individual who's going to be part of the PFA is not notified. They don't have a right to be in court. They're showed up, and the judge will review the application to determine whether or not an emergency order is necessary. So, for example, a young lady would show up and say, I was out with my boyfriend. He got loud and, he punched me in the face 6 times, right? Or something to that effect. They'll go in front of the judge. They're open 24 hours a day for these emergency orders, and they will be issued an emergency order should the judge feel that the standard is met, that they need to issue this order now for immediate protection of the individual applying for the PFA. When they do that, the emergency order is granted. The sheriff is then ordered to personally serve on the other party that PFA. So it's not something that goes through the mail. It's not something that goes through FedEx. They have to get personal service. Now, the law mandates that there should be a final hearing within 10 days of that emergency order. The emergency order provides everything that would be in a final order for PFA, but it's supposed to be a temporary order, right? It's supposed to be an emergency order designed to protect the individual for a period of time until we can get a full hearing. Hearing has to be held statutorily within 10 days. If the individual who's subject to the PFA as the defendant asks for a continuance, that's fine. They will have to agree to continue the temporary order, but the law says within 10 days. At that hearing, it's in front of a judge. There's no jury. It's a private civil matter, protection from abuse hearing, and they have to prove by a preponderance of the evidence actions that were committed by the other party meet the definition of abuse under the PFA statute. So they have to try that familiar relationship as defined in the statute and some abusive. So physical violence, threatening of bodily harm, following an individual with the idea that you're going to put someone in fear of reasonable bodily harm, something to that effect needs to be proven. If the judge believes that by a preponderance of the evidence, more likely than not, they can issue a final PFA. The final PFA order can be up to 3 years. Doesn't have to be 3 years, but the maximum possible can be up to 3 years. It could be 1, 2, 6 months, however the judge decides it. And in order to extend it beyond that date, the plaintiff, the individual who complained about the abuse in the first place, needs to come back to court, get in front of the judge, and show continued fear, continued allegations of abuse. That's generally pretty tough to do, because if you violate a PFA order, you can get charged criminally with indirect criminal contempt, punishable by up to 6 months in prison because you willfully violated a PFA order to stay away from a person. So if there's no violations of the PFA, if an individual comes back in 2 years and says, I'm still scared, the judge what happened, I haven't seen him in 2 years, it's very unlikely that they get extended beyond that. Because typically when they get extended, you're like, oh, this guy's violated the order 6 times. I think we need to stick this out a longer period of time. But that's generally the process. And with that process, generally they will strip an individual pursuant to the order of his right to possess firearms. Although Mike and I talked about that today, we've had experiences where a judge in Pennsylvania will not order either individual to relinquish their firearms, and they should be okay, keep my guns. The problem is 922G says if you're subject to an active PFA, you're a prohibited person. So I go, Judge, I respect your authority, but it doesn't really matter.
Yeah. I want to go back to the historical analog, because you're a big history guy, right?
Well, that's my undergraduate degree, yeah.
You get a degree in history. Mm-hmm. And so this is right up your alley, having to dig into what could have stripped somebody of their Second Amendment rights back in those days, right? And you've seen, we heard that argument regarding whether or not people were put to death for certain offenses back then. Do you want to get a little bit into that?
Yeah, so the Range decision has a paragraph by the judge, and I applaud the Range decision. I think it was the right one. But there's a certain argument the government made, and you and I and a bunch of others that deal in this aspect of the law thought was a really good argument, in my opinion, for the government. They said, hey, listen, colonial period, here are a list of crimes, and the punishment was death. And if they stripped your life, you necessarily lost your Second Amendment rights. You couldn't exactly take your firearms with you. And I'm like, that's an interesting argument to make. I never thought of looking at it that way, right? So if you're convicted of, rape of a woman, they killed you. Okay, there's nothing specifically that says we also strip you of your Second Amendment right to, carry a firearm for the rest of your life, but we killed you. That seems like a reasonable analog. The Range decision paragraph says, well, that's not really the case. Just because they killed you doesn't necessarily mean they would strip you of your Second Amendment rights. And just because they included a greater punishment than we include now doesn't mean they necessarily included the lesser, which would be stripping of your Second Amendment rights. And that honestly puzzled me quite a bit. And if that's adopted broadly, I would be very shocked, because that doesn't, when you talk about, passes the smell test, I go, I don't know about that one.
Now, I think what kinds of crimes would you be killed for back in those days?
Well, see, that's the other thing and I think part of his argument is like trespassing. They could kill you for that.
Whoa.
Theft crimes, they could kill you for that. Things that you're like, they did what? So you walk on my land, you're allowed to die? Yeah, trespassing was a crime. When you talk about private property rights back then, it was protected much more than it is today. But there's some crimes that we would think of as relatively minor today, theft crimes and that they could put you to death for, where they couldn't put you to death today. But the situation becomes, when we got certain crimes, I think you make that argument, it's a bit ridiculous. And that's what the judge said. Like, we have a lot of misdemeanors now. For example, involuntary manslaughter is a misdemeanor crime. There's a dead body involved in that case. That seems pretty serious to me, but it's still only a misdemeanor. And then there's felony retail theft, where you could steal a candy bar from 7-Eleven and get charged with a felony crime. So that doesn't seem very serious, but it's graded. So it's very tough, which is why I think the historical analog tradition test is very good to go. But it presents, which is good for attorneys anyway, lots of litigation possibility.
Have you ever looked at a crime and the grading and just scratched your head and thought, how could this possibly be graded that way as far as the seriousness of the crime? How could this be a felony, or how could this be? I mean, M1, I guess we deal with it fairly frequently because we've got the bookmaking case, which
Right.
you know,
Right, which is bookmaking. And I think my first sentence is, he's basically got charged and convicted for a crime that I think I wrote something like people do on their phones every day. I was thinking about people probably do in your courtroom, Your Honor, while they're waiting to get in front of you, but I didn't know if I wanted to go
we
that
100% saw somebody betting in court one time. I don't know if
In
you
court.
remember this. Yeah, I don't know if you remember this, but
I don't remember that.
we had an emergency case where they picked this lady up on a warrant, and we had to rush down to Philadelphia and
Oh, I remember
wait
that case.
for the arraignment. And we were in with the judge, and all the defendants were there virtually, and it was just us, and there was this other attorney who showed up for another case, and he was an older guy, and he
Mhm.
was sitting there, and he's
And
I see
He
him
was
looking in
betting
his
the
folder.
horses.
He
That's
was
right. I asked him.
he betting the horses, and he had like all these scratch offs falling out of there. This dude is definitely
I do remember that because
Yeah.
I think it was getting close to like the Kentucky Derby or something like that. And I asked him, I'm like, "Who's gonna win, man? I'll bet on the Kentucky Derby." Like we
you,
were sitting
you
there
look like you know what you're talking about.
you
But
know what you're talking about, right?
you name it, this guy was betting on it in the courtroom.
In the courtroom, waiting for his client to argue for me. I do remember that now that you mention it. I
We
do,
should have
but
that guy show up and be an expert witness.
be an expert witness. So, but yeah, I mean, well, I tell you, felony retail theft baffles me. I did an article, I wrote an opinion article in the local newspaper here about a year ago about that, where there was a woman who was like 70 years old, got a felony retail theft up to 7 years in prison, and she was caught stealing a candy bar. And I thought it was the most insane thing I ever did. And the local opinion writer wrote an opinion. I wrote a response. I never write back, and he said, "You should do your own thing." And I did an article in the Morning Call, which is the local newspaper, where I did an opinion piece.
So what were you responding to? What did they
just
what did they
how
say? That it was
serious? Well, it was a good piece because it taught people that if you do this, it's a serious crime, and you're affecting businesses. And I was like, "Are you kidding me?" I mean, what happens is people do this and you get punished for 7 years. I'm like, listen, if you're stealing a candy bar at a store, there's a deeper issue there. And throwing somebody in jail for up to 7 years does not deal with a deeper problem.
Oh, we're
There could
talking
be
about
poverty,
an old lady like that.
So,
Come
I
on,
mean,
give
come
me a
on.
break.
What are you doing?
Now, I do
So-
think that some of these jurisdictions have gone way too far with that.
Oh.
Though. Like some of these places in California where it's like, oh, if it's not over 1,000, we're not even prosecuting. It's like, come on, like, how is anybody supposed to stay in business
Supposed to
when
stay
you've
in
got
business
stuff like that?
Right.
Right.
But
If
it's a
you-
matter of degree, right?
Yeah.
And if you're stealing $1,000, I can okay with a felony. You're stealing a lot of money. If you're stealing a $3 candy bar, you're charging with a felony. I got a problem.
Have you seen these videos with these groups of people? They walk through and they just take everything because they know that they're not going to get in any trouble because they're not supposed to prosecute for certain amounts over there. And we're talking about the rights of business owners and everything. There have been businesses who have had to shut down because of the way this stuff is being treated. And this is coming from somebody who I've never been a prosecutor, obviously,
No.
right? I'm on the other side through and through. But you'd have to be blind not to recognize that you can't have a functional society like that. But we're talking an old lady steals a candy bar. Felony and jail time is probably not the solution to that one.
And that's why you got to do individualized. If a person comes in there brazenly taking stuff off the shelf, if you send that individual to jail for a few months. Even as a defense attorney, I'm going to argue as his attorney not to, but I go, all right, maybe you got to learn a lesson. Maybe that teaches somebody something, right? And it's individualized to the particular person. I don't think you can make blanket statements. That's tough.
So are there any other crimes that you see on the forefront that would be ripe for this kind of a challenge as far as constitutional
Successful
as applied?
challenge?
Yeah.
I think you got to look at, I think DUIs would be one. I think that's ripe for a challenge.
That prohibition was upheld under the old standard, the Holloway case.
Correct, because they felt it was sufficiently serious because everybody understand the dangers of DUI, that it was sufficiently serious. The majority of states penalize DUIs, especially repeat offenders. Because in Pennsylvania, you'd have to have in order to be prohibited under federal law, it's a second offense, highest rate, or that you had so it's a blood alcohol above a 0.16 or a drugs in your system. So that would make it a misdemeanor of first degree.
Or a kid in the car, right?
Or a kid in the car, right? Or a third offense beyond. So at that point, I think you're right for a challenge there, because I think looking at the historical tradition, I don't know if you're going to find an analog whereby they could point to that this individual similarly was disarmed. I think a DUI. Any sort of theft case, if you have a misdemeanor or the first degree theft case, I think it would be right for a challenge in that particular thing. I think that if you're one of those individuals you talked to Dr. Val with, where it's a misdemeanor of first degree carrying a firearm without a license, I think that's an easy case to make. In fact, that M1 carrying a firearm without a license under the old standard was held to be unconstitutional as applied to an individual. And the basic was like, well, when they looked at the case, they had more than half the states at the time didn't require a license to carry a firearm. And I think you can use that logic in that Brune said you have a constitutional right to be able to carry a firearm in public. Now, it did uphold the validity of those shall issue laws, but again, can you show a historical analog that you're not allowed to carry a firearm? That's literally what the Brune case was about, and the government couldn't show a historical analog that they would prohibit concealed carrying or carrying of firearms in public. So,
and
those individuals,
we could really go down the list with all of them, right? And
yeah, I think it's a valid point. So if individuals want to restore their Second Amendment rights, especially for a misdemeanor one, felony, even a felony like a retail theft, I think you may run into a bit more trouble. Maybe not in the Third Circuit, but I think you may get in a bit more trouble because of those, as we talked about, those concurring opinions. And I think that they can put that in. But if you have a misdemeanor of the first degree conviction in Pennsylvania, I think there's ripe for a challenge, or at least a conversation about an as-applied challenge to restore your Second Amendment rights. Now, after talking to the client or potential client, I may give them advice one way or the other. But, I mean, you have a misdemeanor crime, it's classified as misdemeanor for a reason, and we'd have to think about how serious that crime was or what they thought about it in the founding area. Like our client that we have is gambling. And right. Our research, and don't get me wrong, it's not an expert in-depth research, but gambling was prevalent in the colonies anywhere. And based on a tip my fine colleague here, Mike G, gave me, it was one of the things that they complained about because the King of England put a restriction on gambling and lotteries, and they're like, nope, we're out of here. we're out of here. Nope. We're okay with your taxes. We're okay with your militarization. I'll let a soldier stay in my house, but you say I can't play cards, we're out of here. So I'm like, I don't know how you're gonna do this one, because I'm gonna say, it's just, I think there was a quote, and I'm gonna forget the author, but he did the history of gambling in America, and he said, gambling is American as apple pie. And that's how I start that section. He has a long quote. Gambling is American as apple pie. And it's just, when we get up to it, I'm like, that's the thing, right? You have to show, would they have stripped someone's constitutional right to keep and bear arms if they were convicted of gambling? The ultimate answer is no, because gambling wasn't illegal until the mid-19th century, when there was a pushback during religious revival in the United States, where they considered it a vice, and it was people gambled their life away. They couldn't take care of their kids, and there was a pushback. So
Jeremy's got an interesting question. Being that Pennsylvania Section 302 has been ruled not to be a mental health commitment, wouldn't it fail the Brune test?
Well, now I don't know about that, because what you'd have to look at is, would historical tradition or historical analog allow the federal government to strip someone of their constitutional rights for a mental health issue? So it's not a mental health commitment, but does it strip you of your Second Amendment rights? Would be, can you find a historical analog? What we'd have to look into is whether or not, what do they do with individuals who suffered from mental illness or were mentally insane at the time of the founding? The other issue is perceived
to, because you got to keep in mind that they didn't have
there was
the
no
knowledge of mental health that we do today, right? So I
Right.
imagine they'd take a look at a lot of different people and be like, "Oh, that guy's crackers, lock him up," you know?
It becomes, yeah, and that would be an interesting litigation if somebody wanted to get into that. I think, because I bet you would find a lot of laws when it comes to mentally infirm and mentally unstable people. But again, I think to Jeremy's point is a 302 is not a mental health commitment. So are you mentally infirm simply because you're 302? And that's, even if we find it, do we have to then define what is a 302 or an involuntary emergency treatment?
Right. Yeah. So that I think that's kind of like we talked about with the restraining order issue, where the issue isn't well, we're about being able to beat your wife and keep your guns. It's more about the process that's involved
Right.
and the lack of procedural due process protections that are implemented. You've got this lower standard, and you're on the defensive, or you have to prove your innocence essentially in a lot of these situations.
Yeah.
And with a mental health treatment, you're dealing with not any sort of tribunal or anything who's making a decision. There's no neutral fact finder by any stretch of the imagination. And you're just having a doctor take a look at somebody for a couple of minutes and signing off on a piece of paper based on allegations or who knows what else.
Absolutely. And the doctor, and the issue is whether those allegations are true or not, is probably not something the doctor's going to investigate. If we're like, hey, police writes a report, I showed up, this guy was suicidal, said he was going to kill himself, he's not going to sit there and go, where's that cop? Let me get him on the phone and talk to him for 20 minutes. He's going to look at that. The guy's threatened to kill himself or kill his wife or whatever. Doctor's like, yeah, we're going to sit this guy in here for a few days to make sure he's okay. And that's all it takes.
You mentioned it in the police aspect, which is interesting. It's really difficult. They're really not going to question a police officer. And how many times have you caught a police officer lying on the stand, would you say, throughout the course of your career?
Oh, a lot. I like Mike's
Plenty, right?
too. Plenty, where the guy said he came around a corner, he had a gun to his head, and we were drawing him. We just told him to stop. And Mike, I believe, asked the question, like, wait a minute, he came around, had a gun pointed? Yeah, you didn't shoot him? No, you guys are the greatest police I've ever met. Which is another way of saying I don't believe that happened at all, because you have all these guys down there hyped up, ready to go, got this report of this nut who's about to kill himself or shoot somebody. He comes around the corner with a gun. Not one person fires a shot? No. Wherever you guys trained, we got to send every police officer in the world. Because if you would have shot him at that point, and I think you guys probably go too early sometimes, but I go, yeah, I can't argue with that one. You can't come around a gun. Like,
another interesting one about that one is I knew the layout of the house, and I asked each of them individually, they were sequestered, where they were standing, and all of them were at the bottom of the stairs. There was absolutely not enough room for all of them to be standing at the bottom of the stairs the way this layout was, unless they were like they were giving each other piggyback rides in order to be at the bottom of the stairs stacked on top of each other. It wasn't possible. But the point is that police occasionally lie, but doctors are going to take their word as gospel. Take that a step further, because in this 302 process, you have these doctors who are taking the word of not a police officer, who do occasionally lie, but like the scorned ex-wife who's got every reason to lie about this guy. They say something, and that goes in there, and the determination is made based on that allegation. So there is an interesting issue there. I just don't know how it fits with the historical analysis, right?
Right, and that's really where we're gonna have to struggle, because with the historical analysis, the way they treated people they believed had mental deficiencies or mental illness was pretty harsh, because they didn't really understand, and they basically threw you in an institution and scorned you from society. So, I mean, there's two sets of questions, and I think it's interesting, and it'll eventually be litigated in court. But I mean, the other issue is, how do you define those boundaries? And the interesting part, I mean, from a legal perspective, when you're coming into something like that, is not only do you have to argue that my client's Second Amendment rights should be restored, it's just the court may eventually ask you, well, what are the boundaries you're looking for? And how do I fashion boundaries sometimes about what it is. Before we had the Bruin decision, you and I, in this case that we argued in as applied challenge, we were looking for definitions of particular terms. We have to suggest definitions about, we don't really define what consensus is, but I was like, well, you got to tell me what it is, and how do you define that? And it's always a challenge because you want to make sure you do a test that your client wins, but is also helpful to others. And I mean, that's going to be a challenge for a lot of lawyers in this area.
Yeah, we're going to see a whole lot of litigation coming down in terms of this. But what about, I just thought of another M1, possessing instruments of a crime. That would be an interesting one, right?
That would be. And then does it matter factually, right? Do we have to look at it factually? What was your possession? What did you possess? Because did you possess a firearm, or did you have a knife, or did you have a club that you used to break a door? I mean,
it could be a lot of different things, right? It could be a screwdriver.
A screwdriver. You possess an instrument of crime. You use a screwdriver to pop a lock or start the key. I don't know how you do it now because no cars have keys. You just use a screwdriver to pop the cylinder. See, I'm an old man now, Mike. Yeah, nobody's like, how do you do that now? He used to pop the cylinder and use the screwdriver to start the car. That's a possession of instrument of a crime. I don't know.
And what about these hacking crimes that they have? That would be interesting too, right? Or would that be analogous to like some kind of a stealing or
a theft case, right? And then how do we punish theft cases? I think theft cases will be interesting. The good thing about being in the Third Circuit with theft cases is that range decision, although I think it's a little iffy on the opinion about just because they killed you doesn't necessarily mean they stripped you of your Second Amendment rights. That would be the argument that would have worried me in a case like that, right? If I came with a theft case, I'm like, yeah, well, somebody stole this amount of stuff in colonial America or Pennsylvania. They killed you. They hung you. You lose your Second Amendment rights, you're dead. Like, no. Just because they killed you doesn't mean you lose your Second Amendment rights, and cite that paragraph. Begrudgingly cite that paragraph. Look at the judge. I go, I didn't write it, judge. It's what the law is. I don't know what you want me to do.
Yeah. You are bound, Your Honor.
You are bound by that opinion and that paragraph. And he's just looking at me, and I'm looking at him like, I don't think it's right. But unfortunately, somebody overturns it. I'm using it.
So we're really going to have to learn a lot about the specifics of the history. I do have one more question for you before we wrap up. Now, you have been utilizing this opinion along with the Second Amendment jurisprudence as it's developing to litigate your criminal cases, haven't you?
Yes. So it's becoming a somewhat of an effective tool for possessory offenses, mainly. So Pennsylvania, if you're prohibited by federal law, you're also prohibited in Pennsylvania from possessing a firearm. There's some additional things, but that's the general idea. So they'll charge you with possession of a firearm by a prohibited person. And the reason you're being charged with that crime is because you're prohibited. And if I have to dig into their criminal history and to see what they've been charged with, I had a recent case where the individual had, I think, some drug or theft related offenses. The original offer from the district attorney was 24 to 36 months in state prison. After the range decision, I emailed him because we had court in a few days. And I said, hey, I just read this decision. I don't know if you heard about it. I looked at his background. Here's why he's prohibited. I would file a motion to argue you can't prosecute him, blah, 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 blah. Gave him the issue. Told him that, I figured I'd reach out to you. Can we come to some sort of plea agreement where you keep my guy out of prison, maybe put him on probation and send him home, and saves us both a lot of work. Fortunately for the DA, is like, I agree with you, and I don't really feel like arguing about this, so we'll agree to something for probation and send it on your way. And, I mean, I went to district attorneys about it, and it's been successful so far in getting me better plea offers, which my clients have eventually accepted in every case. It'll be interesting once somebody says no. Recently did a case in, I'm going to call them out, Lancaster County. Their position right now when it comes to possession offenses or even Pixtonile cases that we talked about, if it's a non-violent, the way they read range is any non-violent crime, it is unconstitutional to prohibit somebody from purchasing or possessing a firearm. In the case where I was in Lancaster County recently, he was convicted of corruption of minors in 1993. They determined that that was not a crime of violence. They offered to settle that case for him paying a fine, basically, and he was done. So it's really going to come without litigation. The DAs are going to come to some position for it, but
yeah, they have to, right?
They have to.
They have to do something,
or they're going to litigate it. So I mean, the nonviolent crime, again, I don't think that's the case, but to help my guy out, I think it's a pretty broad reading, and I appreciated that. I think there's some other cases that I have where individuals have drug-related crimes. There's a case that I currently have where that is. I believe we're going to reach out to the DA, file an associated message. The other one, however, I'm thinking about it, his conviction was for robbery. So, I don't know how I'll have to litigate that or how much I'll have in that particular case, but I mean, it's difficult. I don't know, but
that one dude is manslaughter, right? So
yeah, that was I don't know how well that's going to hold up, to be honest with you, but he did 16 years. I'll be surprised if that holds up, and I will admit I was wrong, but I went, I don't know about that one
until you hear otherwise.
Until you hear otherwise, right.
As far as the cases go with possessory offenses. You were saying that drugs is one that you're looking to litigate. Would that be something that you would potentially do an as-applied challenge on? Because what's your understanding of the founding era position on drugs?
Well, drugs, again, like gambling that we were talking about, really didn't start to become prohibited until the mid to late 19th, early 20th century.
Man, the United States used to be awesome. No, I'm just kidding.
Used to be awesome. And I'll give you an example. So I was, as a history guy, I was on some website and they were talking about, history of drugs in America, right? And there was an advertisement from the late night, it was like 1890 or something, where Bayer, the same people, Bayer aspirin, was advertising a brand new miracle drug, heroin, where you could take it to relieve headaches, nausea, sleep disorders. It would help your kids calm down. And they sold it over the counter. There's literally an advertisement for heroin. They didn't realize till 10 years, 20 years later, the addictive properties, and it causes a lot more problems, but they marketed it as a miracle drug. Cocaine was the same way. It was marketed as a miracle drug when we first discovered what it is. So I think possession of drug offenses, distribution of drug offenses are prime for an as-applied challenge, just because of it maybe not even be the permissive nature of drugs in the founding area, but there's no crimes associated with drugs because I don't think back then they fully understood the ramifications of firearms back then. And we talk about DUI crimes, the prevalence of drinking. Come on, what are you doing?
What about were there any drugs that would be off limits back then? Like, did they say like peyote, stay away from that or anything? I don't know.
Well, restrictions on peyote, Justice Scalia said was illegal because it was a viol, or it was fine because then they did the Religious Freedom Restoration Act because it was
that wasn't an as applied challenge, was it?
As applied
challenge, yeah.
So, and I mean, but the problem is there's not many anti-drug laws during the founding era. It was only as they came forward. There was opium dens everywhere, especially on the West Coast. It was a big industry back then. So, I mean, I think the way you could try to analogize it, what do we do to an addict or a drunk? But again, just because you possess firearms or possess drugs or sell drugs doesn't necessarily mean you're addicted to them. And there's some arguments that go there, but yeah, it's just a lot of the modern attitudes that we have towards substance abuse and alcohol and things like that, gambling, doesn't come till later on in American history, when I think there was either, religious revival in terms of gambling, a broader understanding of addiction and the pain and the suffering that it caused and the destruction of people's lives. But when it comes down to it, I mean, the relevant time period the Supreme Court has said is at the founding, would this behavior strip somebody of their Second Amendment rights? If the answer is no, then it shouldn't. So again, yeah,
we might be going a little bit towards a standard of, basic criminal law and in law school, the most foundational class that you take talks about malum in se versus malum prohibitum, right? The difference between a law that makes something illegal just because it's prohibited, or illegal because there's some kind of inherent wrong about it. And in the brief that I wrote for the gambling case at the lower level, I found some case law and some treatises where they talked about these gambling offenses simply being malum prohibitum. And it's only illegal because it's prohibited and nothing else. Do you think that the standard that we're seeing unfold here is more of a standard that goes along those lines? If something's illegal just because the government says so, just because we've had so much stuff over the last couple of centuries where the government just increasingly adds these prohibitions.
Right. That's an interesting. I will admit I've never thought about that, but I like that argument a lot. Is it illegal just because I said it's illegal, or is it illegal because it's evil? Right? Is it something that's always been prohibited, like murder? It's has been illegal since the Greeks, right? You can't kill somebody for no reason. You can't. That's prohibited, not because the government said we don't want you to kill it, but it's prohibited because the government says, but also because it's inherently evil. I think that might be an interesting distinction to advocate in the right case.
Yeah.
Right. And that drug case might be a way to argue that as some pushback. I think if they're looking for a standard.
And that's another thing, though, because the drugs that are legal versus illegal change all the time, right?
Right.
Just like pot wasn't prohibited. I guess nobody calls it pot anymore. I sound like an old man, right?
You are an old man, Mike. You come join me on this side of the tracks.
What are they calling it? What are they calling it these days? Cannabis, or I think that devil's lettuce is the proper terminology. The wacky tobacco. So
now you are really old.
So back in the day, when we're talking, like you were saying, the founding era, not illegal. Then it becomes illegal. Now we're seeing this shift back towards, hey, that was kind of stupid, not illegal. And with these things rotating in and out of what's okay but not okay based on what the government says, is that right? The only thing it's based on.
Or new understanding. I'm sure they'll say it's a new understanding. I'm like, well, okay, so you got it wrong.
How do you know your current understanding is not going to be overturned by the new understanding,
Exactly. And I think that goes to, especially when it comes to marijuana, is a perfect example. It's terrible. People get addicted. They're lazy. And then they're like, well, it helps people. It's better than opioids. It gets rid of pain. It helps with PTSD. Maybe it's not so bad. It's not any worse than alcohol. All right, we're good. and they go, well, now we've had it and there's more problems. And I know, and then you're right. It's illegal, then it's legal, and then it's a private choice, but it's not a private choice. We need to protect. Yeah. And I like that. That could be a standard. It'd be interesting to go through litigation and figure that out.
You can't tell me it's exponentially worse than the opioids. I mean, I hear people try to justify the fact that it's a Schedule 1.
Cocaine.
Cocaine's
a Schedule 2.
Right.
So is heroin, by the way.
Oh, wow.
Well, because it's a derivative of morphine. So morphine is also illegal.
You can't quite just give it to the kids anymore to make them go to sleep, but
no,
still not as bad as marijuana.
No, marijuana is the worst. Schedule 1, no benefit whatsoever. And I don't know. I mean,
so
but
do you
you're right.
think that would be like the good case is if it was based specifically on marijuana or something like that?
Yeah, it could be. Marijuana is a good example to use, but I think any sort of drug conviction would be any sort of either possessory offense when it comes to drugs, or even drug distribution, because I've used that in cases. My client's been convicted of, PWI, possession with intent to sell. I go, you're going to have a tough time finding an analogy that you couldn't sell drugs. And I've used advertisements of Bear as heroin and Bear as cocaine. So if it was legal for Bear, who's still around today, a bazillion years later, to sell, I got to find a hard press. You're going to find a historical analog or historical tradition that says if you had these substances, it would be illegal to have, and you're not going to find it.
To wrap this all up, Rich, I really appreciate you joining us. This has been a blast of a conversation. I hope that we get to have you back on soon to discuss this stuff further as these cases develop. But I want to leave it off on a high note, so to speak. We'll call it a high note. DG says, explains why cocaine happened to be in the White House. It's been sitting there for 200-something years.
200 years. We are going to use that. They just found it. If George Washington was using cocaine, they definitely wouldn't strip his Second Amendment rights for using cocaine now.
That's all the time we got for today. Stick around for We the People, the Constitution Matters. Pastor David Whitney, Professor Philadelphia. I'll be joining as your legal analyst. We miss you, Ellie.